Assalamualaikum and a very good morning to my dear lecturer Puan Zubaidah and my dear fellow friends. Today I'm going to present chapter 7, which is winding up. Okay, before that I want to introduce myself and my group members. I'm the first presenter. My name is Nur Nazila binti Al Faizal and my metric number is 01D80F1043.
My name is Nurul Iza binti Muhammad Faizal. My metric number is 01D80F1039.
My name is Nur Adriana binti Muhammad Nasiruddin and my matrix number is 01D80F1040. Today I will be the last presenter for this presentation.
Okay, now I want to tell what is winding up. Winding up is a process in which existence of a company is brought to an end, as well as the assets of the company collected and realized. The proceeds collected are then used to discharge the company's debts and liabilities, and remaining balance, if have any remaining balance, it will be distributed among the contributories according to their entitlement. Okay, now I want to explain about voluntary winding up and the sections for that. Then I will explain about every sections. Section 441, date of commencement of winding up. The second section is section 443, declaration of solvency. Section 439, subsection 1, circumstance in which company may be wound up voluntarily. And the last section is section 439, subsection 2, procedures for voluntary winding up. In accordance to section 441, a winding up shall be commenced where an interim liquidator has been appointed before the resolution for voluntary winding up is passed, at the time when the declaration referred to in section 440 is lodged with the registrar, and in any other case at the time of the passing of the resolution for voluntary winding up. On the other hand, according to section 443, a declaration of solvency is required before a company may commence a member's voluntary winding up. The majority of the directors should ensure the following, which is make a written declaration to the effect that the directors have made an inquiry into the affair of the company, and at a meeting of directors have formed the opinion that the company will be able to pay its debts in full within a period not exceeding 12 months after the commencement of the winding up. A statement of affairs of the company shall be attached to the declaration containing the particulars made up to latest practicable date before the making of the declaration as follows. First one is the assets of the company and the total amount expected to be realized. Second one is the liabilities of the company, and the third one is the estimated expenses of winding up. Section 439, subsection 1 specifies that a company may be wound up voluntarily if the following circumstance occurs: when the period, if any, fixed for the duration of the company by the Constitution expires, or the event, if any, occurs on the occurrence of which Constitution provide that the company is to be dissolved, and the company in general meeting has passed a resolution requiring the company to be wound up voluntarily, or if the company so resolved by special resolution. The last one, the section 439 subsection 2 specifies the following procedure for voluntary winding up. A company shall lodge a printed copy of the resolution with the registrar within 7 days from the passing of the resolution for voluntary winding up, and give notice of the resolution in one widely circulated newspaper in Malaysia in national language and in the English language within 10 days after the passing of the resolution. Before I giving my presentation to my second presenter, I want to explain about what is liquidator. Liquidator is an independent and qualified person to investigate the affairs of the company during the process of winding up. The power and duties of a liquidator are vested in 12th Schedule of the Companies Act 2016 for winding up by court, while 11th Schedule for voluntary winding.
Thank you, Nazla. Now, I will be to continue to our next part in our presentation, which is the categories of voluntary winding up. The categories of voluntary winding up can be divided into two types, which is the members voluntary winding up and the creditors voluntary winding up. First of all, I will be talk about the members voluntary winding up first. In section 432 subsection 2A in Companies Act 2016, it says by a member's voluntary winding up where the company is solvent and the liquidator is appointed by the members at the members meeting. Next, in section 444 in Companies Act 2016, a declaration of solvency is made by the sole directors or majority the directors. Next, I will be talk about the creditors voluntary winding up. In section 432 subsection 2B, it says by a creditor voluntary winding up where the company is solvent and the liquidator is appointed by the creditors at the creditors meeting, and it says there is no declaration of the solvency. Members voluntary winding up. With reference to the section 445 of the Act, members voluntary winding up is a case which of the shareholders of a solvent company adopt a voluntary winding up resolution and appoint a liquidator to realize the asset of the business in order to distribute the proceeds to the company members. A company is considered as legal solvent when it is able to meet its financial obligations and the value of its asset. For example, the equipment, the inventory, the plant, the property, the contracts, the invoice, the bank funds, and so on exceeds the total sum of its debts and liabilities. In accordance to section 443, in order to enter the members' voluntary winding up, the shareholders of the company should make a declaration of solvency, which states that they have throughout reviewed the company's balance sheet and finance and have concluded that it is solvent and able to repay the existing and prospective debts within a period, but no more than 12 months after the commencement of winding up. In appointment and removal of liquidator in section 445 in Companies Act 2016, I will be explained in our next slide of our presentation. Now, I will explain about the power to fill vacancy in office of liquidator in section 446 in Companies Act 2016. Vacancy of liquidator may occur by death, resignation, or removal. Such vacancy shall be filled by any arrangement with its creditors. A meeting may be convened by any contributory, or if there is more than one liquidator, by the continuing liquidators. Such meeting shall be determined by the court on application by any contributory or continuing liquidator. Question 1. Describe the appointment of a liquidator under the Companies Act 2016. In section 445 of the Companies Act 2016, there will be talk about the appointment and removal of a liquidator. This section will answer the first question. Without wasting any time, we will go through the first subsection in this section. In subsection 1, in a member's voluntary winding up, the company shall appoint one or more liquidators for the purpose of winding up the company's affairs and distributing its assets in general meeting. When a company is solvent and a liquidator is appointed by the members during the meetings of members winding up. Next, in subsection 2, the appointment of a liquidator, all the powers of the director cease, except or so far as the company in general meeting with consent of the liquidator, or the liquidator sanctions the continuance of all the powers of the directors. Next, in subsection 3, the company may, in general meeting, convened by any contributory by special resolution of which special notice has been given to the creditors and the liquidators. Remove any liquidator, but no such resolution shall be effective to remove a liquidator if the court, on the application of the liquidator or a creditor, has ordered that the liquidator may not be removed. Next, I will be talk about the company winding up by court. For your information, the company winding up by court, also known as the compulsory winding up. In subsection 464 under the Companies Act 2016, a person who have local standing in petition of a compulsory winding up are, in subsection A, the company; in subsection B, any creditor; in subsection C, a contributory or personal representative or trustee; in subsection D, the liquidator; in subsection E, the minister; in subsection F, the licensed institutions; the subsection G, the operator of design of payment system; in subsection H, the registrar; and last but not least, in subsection I, the member institutions. Question number 2. Discuss 12 grounds as the circumstance for a compulsory winding up. Next, I will state the 12 grounds as the circumstance for a compulsory winding up in section 465 subsection 1a until L in the Companies Act 2016. But in this presentation, I will only state 4 of them, and the rest will be presented by our next presenter. Now, first of all, in section 465 subsection 1a, the company passed a special resolution that the company is to be wound up by the court. Next, in section 465 subsection 1b, the company default in lodging the statutory declaration. Next, in subsection 1c, the company does not commence business within a year. Next, in subsection 1d, there is no member in a company. That's all for me. Now I will invite our next presenter, Nur Adriana, to continue with our presentation.
Thank you so much, Nurul Izzah. Now I will continue the presentation for 12 grounds listed as circumstances for a compulsory winding up according to section 465, subsection E until L. The inability of the company to pay debts as discussed in section 466, subsection 1. Section 466, subsection 1a, neglect to pay the in-debt sum exceeding Rm 10,000 after receiving the notice of demand from creditor and notice 21 days has expired. Section 466, subsection 1b, the company fails to satisfy the execution or other process in favor of the creditors. And the last one is section 466, subsection 1c, the court satisfied that company unable to pay debts. For subsection F, the directors act for their own interest. For subsection G, the company expires as being stated in the situation. For subsection H, the court is in the opinion that it is reasonable that the company be wound up when the first one is the substratum, which is main object of the company no longer achieved, or the company is gone. The example case is Pyrie versus Stewart. The second one is the management is carried on in such a way that the minority is disregarded. The example case is Ibrahimi versus Westbourne Galleries, CTD and ORS. There is a deadlock in the management of company. The example case is Yanich Tobacco Co. Ltd. And the last one is the company was formed to carry out fraudulent or illegal business. The example case is Brinsmith, which is Thomas Edward and Sons. For subsection I, the company license under the Financial Service Act 2013 or the Islamic Financial Service Act 2013 has been revoked. For subsection J, the company has carried on without being duly licensed. It is deposit in Malaysia in violation of the Financial Service Act 2013 of the Islamic Financial Service Act 2013. For subsection K, the company is being unlawful purposes of any prejudicial or it is incompatible without peace, welfare, security, public interest, public order, good order, or morality in Malaysia. And the last subsection is L. Declaration has been made by the Minister under Section 590. This is the question 3. The question asks the director the procedures required to dissolve company based on the situation given. There have 6 procedures. The first step is members of the company to pass a resolution for the winding up of the company. The second step is the declaration is in a written statement of solvency to be prepared and executed at the board of director meetings. The third step is the company is able to pay off its debt in full within a period of not exceeding 12 months after the commencement of the winding up. The fourth step is members of the company to appoint a liquidator. Liquidator will need to deal with the formalities of appointment. The fifth step is the company ceased all operations save and except for function necessary for the winding up process. And the final step is liquidator takes over all affairs of the company and proceeds with winding up. So this is our references that we use to make this presentation and PowerPoint. That's all from us. Thank you for listening.